Thank you, Adedumade. Thank you for the invitation. And of course, this is a very fantastic training event opportunity for us to share ideas. And I don't like not yet. I don't like the description expert, not yet. I don't introduce myself as an expert. I don't refer to myself as an expert because that word or that appellation comes with its own burden, which I'm not sure I'm ready to now start, especially when people start asking you very funny questions that you yourself cannot answer. Okay, so very quickly, because I see, please, you need to enable me so that I can share my screen so that we can quickly, I'm going to be very fast so that if we have questions afterwards, we can ask questions and we can share ideas on this. So, yes, thank you. Where is it? Okay. Yes. So, is it? Yeah. Okay. So, this is just what I'm talking about, and the content. So, at the end of the class, we will talk about. We would have spoken about forms of privacy because this is about privacy and data protection. We will talk about the meaning of data protection, brief origin. I just want to take you down memory lane. Methodology, major terminologies, some principles, then the rights and the remedies of data protection. But we will talk about privacy first, because sometimes when we start talking about data protection, we might get carried away. Then we might not even come back to privacy. So the major forms of privacy, that is the interests that privacy seeks to protect, or the appearance of privacy, because it comes in different forms now. The first one that all of us know, the first one that lawyers litigate, the one that we are familiar with, is that intrusion into seclusion or solitude, or your intrusion into your private affairs. So anybody that intrudes, we will say, oh, you are invading my privacy, or you will say you have interfered with my privacy. And we can easily litigate that. We know when it is done. Maybe somebody comes into your house to search, unlawful search. Maybe somebody looks into your personal information. Maybe somebody eavesdrop. Maybe somebody interferes with your communication. Well, I'll speak to all those ones later. Then the second one is appropriation of images. That one too, we have litigated it a bit in Nigeria. Then the third and the fourth one are the ones that are so strange to the Nigerian jurisprudence, but we will speak to it. So intrusion, we are all familiar with protection of personal autonomy, your bodily privacy, let nobody give you injections that you don't want, or give you blood transfusion, or, those are things that you want to have control over. Then thoughts, you don't want anybody to intrude into your thoughts, your thought process. Then choices, the choices you make, the desires, let nobody interfere with it because it is personal to you. Then the conversations you have, you don't want anybody using, unauthorized storage or access to your conversation, whether letters, whether SMS, whether we've litigated a bit. Privacy is the least litigated or researched fundamental rights in Nigeria. That one is certain. You won't see so many materials. When I was writing my book, I had to refer. If you check, I have referred to so many foreign authorities. You won't find so many in Nigeria. We're just developing, we're trying, but we'll get there. Then privacy of home, yes. So the most popular case, or the only case that the Supreme Court has even touched on privacy, is this case, MDP, DCT, and Okonkwo, and it has to do with blood transfusion. An adult refusing blood transfusion, and the court, pronounced on your right to refuse, even if it will lead to death. It's your decision. It's your decision, and that is similar to what they have in America. They are taking it further extreme on abortion rights, safe abortion and everything, but that's not my That's not my business today. Then the other one is appropriation, misappropriation of image or likeness. We always say we don't have image rights in Nigeria. We don't have the law regulating image rights. But Section 37 of the Constitution is extremely important for that, because these are forms of privacy. So image rights, somebody cannot appropriate your image for their own benefits. So it's not just the use of image, but for commercialization, but for some other purposes that brings benefit to them. It implicates privacy. Use of photographs or even copyright. So there are some cases that have gone up to Court of Appeal. And it is our knowledge, with respect to the lawyers, the knowledge of privacy sometimes will not even allow you, that is the lack of knowledge, might not allow you to identify causes of action when you see them. Privacy causes of action. Now, in Bicotney's case, yes, at the airport, Bicotney used the picture of someone to advertise at the airport without the person's consent. They got judgment. In Access Bank and Bulama, they used the picture of twins, infants, to advertise. They got judgment and under privacy, rightly. But in Banire and NTA, they used somebody's photograph to advertise. The person was claiming copyrights, and the person lost because she was claiming copyright. And you know, copyright has its own factors. You must be the author, licensee or assignee, and all those things. But if they had litigated it under privacy, things would have been different. And that's where knowledge comes into place. So where you appropriate this thing. Now, this one, we do not have any jurisprudence on it in Nigeria. When you publish embarrassing truth, not lies, or fact, but when you publish such fact and the subject is embarrassed, that's a violation of privacy. But our jurisdiction has not gotten there, or our jurisprudence. Nwachukwu and Nwachukwu was close, but the Supreme Court did not even touch on privacy. Supreme Court said the subject matter wasn't about privacy. It's a quarrel between husband and wife. The husband disclosed the wife's HIV status, and some people came in to pack the wife's load out of the house. The wife sued them for invasion of privacy, fundamental rights, privacy, and everything. But the court said no, it was much more about fundamental rights. That case had its own huge shortcomings on development of privacy. The most interesting one is publicity in a false light. This one, there is no authority on it. Even the authority, even in the UK, it is just developing. You can only find 1 or 2 cases, or 3 maximum, on it in the UK. Meanwhile, it is a form of privacy. As opposed to publication of embarrassing facts. This one is publication of falsehood, publication of lies. But you are publishing, you are giving somebody publicity, but in a false light. You know what they used to say? That there is nothing, whether good or bad publicity, it's good. Or I don't know how they say it, that there's nothing wrong with bad publicity, or there's nothing like bad publicity. This speaks to bad publicity. And the people that really suffer this are celebrities, most times. There are some cases where, I'll give you an example. A man and his wife and his daughter is a case in the US. A man and his wife and his daughter went on vacation. The man pecked the wife. Some people took the picture and they used it to write a newspaper story. And the headline of the story is, "Love at first sight does not always end well." Love at first sight does not always end well. Those people took them to court. That come. The impression you are giving, yes, you are publicized. You have not defamed us. It is not defamation. Our reputation wasn't affected. But using our picture for this kind of story gives a false impression that, number one, we had love at first sight. Then number two, that it did not end well for us. But it's a false impression. It's a false light, and their privacy was invaded in the process. So it is not defamation. It is different from defamation. If lawyers understand this, most of the cases in defamation, we won't go by defamation, because defamation is about reputation. I give you an example of, let me use Bobrisky. Bobrisky is a very popular person. Let somebody write something about Bobrisky sleeping with someone or doing something. Then Bobrisky goes to court and go and sue for defamation. in the Nigerian parlance. Bobrisky does not have that kind of good reputation. So first of all, you would be tackling his reputation. And once you can defeat somebody's reputation in defamation, that's the end of the case. Because you are saying the publication has brought you into disrepute. So if I establish that the reputation you are talking about, you don't even have it. Most defamation cases, that's how they end. So in this one, it's a publication but it is false. Then it affects the person's emotion, not necessarily reputational damage. I'm not saying I'm popular. We are doing, in my firm, we have filed, in the past 2 weeks, we have filed 4 of that kind of cases. And we're expecting the court, whichever way the court decides, the jurisprudence would start growing from there. Whatever the court says, we're ready. Because there's no authority on it. And it has not been tested in court. So I'm not saying I have a reputation. Somebody has written something about me. I'm a lawyer. I won't put my lawyer stance or status forward. No, I'm not saying because I'm a lawyer. I'm saying because I'm a Nigerian citizen. I'm saying because I'm a human. You cannot publish falsehood about me, not my reputation. Because for this kind of thing, this kind of course of action, people who don't have money, people who don't have fame, people who are not highly regarded, this is where they can come under. So you are not claiming you are anybody in the society. You are just claiming you are a Nigerian and you are a human. And by virtue of your humanity, you enjoy right to privacy. And that right to privacy protects you from being painted in a false light. So that's it about privacy. We'll quickly move to data protection because that's where we'll spend most of our time. But in the course of this, if you have any question that you think we need to talk about, why not? Data protection, what does it mean? As it states, it is just the protection of humans now, protection of humans with respect to their personal information. Yes, there is this growing argument and advocacy in the UK, even in the US, that companies should also enjoy data protection. But as the jurisprudence on it stands, universally, it is for humans because it is about privacy. A company cannot be talking about privacy. And a company can talk about defamation. And even in defamation, they say it is reputational and it is something that has to do with their income. So it is not necessarily with respect to their character. Now, so there are about 3 parts to data protection. There is the legal part. That's why every time I talk about data protection, I try as much as possible, although the lawyer part of me will always come out, but I try as much as possible to downplay the lawyer part because it is not 100% a lawyer's work. In the UK, in the US, you find non-lawyers doing it all over the place because you just need to understand the principles and you're able to advise your client or advise the company on the subject. Now, there are legal or technical measures or method or control over activities that border on personal data. So for every company that processes personal data, data protection controls it, whether the law or the practice. Then it safeguards personal information. So everything about data protection is, we call it data protection, but it's actually personal data protection because we have computer data, we have non-personal data. We have personal data and non-personal data, but data protection is concerned with personal data. So the origin, we're just catching the buzz in Nigeria, but this has been around since 1970. Last 2 years ago, when I presented my book, I got people to talk about 50 years of data protection in the world or in Europe and the lessons for Nigeria. Shows it's been around for a while, but we are just catching the bug. So 1970, a state in Germany enacted the first ever data protection law in the world. But I need to mention this, the origin of data protection is closely tied to privacy. Privacy originated in 1890 when 2 lawyers, and I'm happy because it was 2 lawyers, because it tells us that we have a lot of roles to play in the development of data protection or privacy, even in the country, in Nigeria, to start with. That's why I'm excited when I get to see lawyers I talk to, because where the development starts is your identification of the course of action. So if you see course of action that relates to data protection or privacy, and you exclude it from your processes, then you have contributed to the stunted growth of that practice area. Because the judges might not even by themselves discover, like cases have gotten to the Supreme Court, and there are cases that implicate privacy, and you won't see anything about privacy there. Nothing. Cases of paternity fraud, cases of HIV status, cases of invasion of homes, and you won't find anything about privacy. But the lawyer, it will always start from the lawyer. So when you see that, and it is easier, that is why I would always advocate for it. These cases that we filed, the client said defamation. We have to sit the client down and say, no, this is not defamation, except you want your reputation to be attacked. And if they are now facing your reputation, then the case itself, except it is blatant lie that can't be established. But if it's something that has to do with your reputation, it's a bit difficult. Let's leave that aside. Number one, it takes longer time to prosecute defamation in Nigeria. If we do how many years at the High Court, if they appeal, we're going on appeal. If they appeal, we're going. But at least if you do less time at the High Court, maybe they might not even say they want to appeal because they look at it and they say, oh, this is a clear violation of privacy. So, but the origin of privacy is 1890 article written by two Harvard trained lawyers, Samuel Warren and Louis Brandeis. You can Google it and you can read up on it. But in terms of data protection, we trace it back to 1970, that 1970 law in Germany. Then in 1973, Sweden, the first country to enact a data protection act or law, in a national data protection law. From Sweden, the convention, the Council of Europe, they passed Convention 108, and that is the first and only international convention on data protection. It is applicable to African countries, but Nigeria has neither ratified nor done anything around it. So it is there. But there are some African countries like Tunisia, I think Morocco, a couple of African countries, they have ratified it, and maybe they've even domesticated it, and they are fine with it. Then from Convention 108, we moved to Data Protection Directive. That was what they were using in Europe before we now got to the GDPR. GDPR globalized data protection, because until GDPR came, before Nigeria opened its eyes to data protection, even some people had written one or two things in the past on data protection, but it was never part of our laws until the Nigerian Data Protection Regulation of 2019. I will always warn people, don't be fixated on NDPR. I will always warn. It is capable of misleading. It's capable of confusing. It's capable of carrying you to places that you don't know. And why I say that is, yes, I am modestly, I can say that modestly, I am the first and only lawyer who has litigated NDPR to the Supreme Court. So I have the bragging right to say that you don't want to build your castle on the NDPR. I enforce it, I go to court, I protect it, but NDPR has its lot of wahala, inconsistencies, irreconcilable differences, so to speak. I have written articles on why the NDPR must go, and you might just want to Google and read it. Now, so you would have to read foreign articles, read cases, read resources outside, so that you can have a very good understanding of data protection. So there are some general terminologies that everybody who is interested in data protection, that one of the terminologies made somebody lose or fail an interview, a job interview in the UK. Because, I mean, Nigerians, we know how to cook CV. We can cook CV, what you don't know how to do. You can put it there, you can even fly aeroplane and everything. But when you get to the interview, there are some, especially with data protection, I used to tell people, is that how you know it? or you don't know it. Well, maybe you can be on the fence. Maybe you can sit on the fence for a while. But even if you sit on the fence, you should tilt more to the side of knowing than, because now with data protection, there are some general terminologies, especially if you want to claim that you've been in the industry. There are some terminologies that even me, I was learning at some point. You can hear things like DSAR. You can hear things like DPIA. You can hear things like PRIA. So many terminologies. But if you are in the field, you will know it. You can hear things like TDF. But if you are in the field or you read things around, maybe you would stumble on some of it. So the most important thing about data protection is personal data. I don't want to speak too much on it, but it is very elastic. Anything and everything that identifies you is your personal data. Everything. And it is contextual. For all I care, in this room, if there are people wearing shirts with emblems, or you are wearing anything with emblems or with logos, that can be your personal data within a certain context. It is not your designer. It is you just bought the clothes and wore. But in a particular context, if that thing you are wearing can identify you, then it's your personal data. For Tinubu, that logo that is on his cap, if you put it anywhere and you say anything, everybody knows, or most people know you're talking about him, then it is personal data. So anything, any information, that's the description, or that's the definition, any information that identifies you. That's why it is very, very tricky, extremely tricky. For companies, you see email addresses, you see somebody's number plates, you see somebody's house address, you see somebody's wife or somebody's daughter or somebody's child, you see somebody's department, can identify them, and they can claim it as their personal data. And don't forget, everything is contextual. Now, processing. Any activity you do on personal data, you collect, a lot of people say that, if you say they process data, no, they say we don't collect data. We don't collect data. If you don't collect data, if you have any bearing on data, you are still processing. We were advising a client who sponsors an event center to do events. They just give them drinks and some money to do the event. And when we were advising them on their exposures, they said, no, for this particular one, we have nothing to do with data. I said, no, fine. Please just share your contract with this event center. They share the contract. There's a clause in the contract. The clause mandates, my client mandates that event center to take pictures and photographs at every event. They don't collect the picture. They don't do anything with the photograph. But you see that contract alone, it gives them a certain status under data protection law, joint controller. So processing is, I was talking about processing. You might not even have direct contact with data. If you control, if you have access, reasonable access, if you have bearing on personal data, then you are processing. Sorry, 1 second. Let me just do this. Thank you. So that's processing. Then data controller. Everybody that has access, that controls, that determines the purpose. That's the definition. The purpose and the means. And the easiest way to understand this thing is contextualize it, make it practical. Just begin to think about where you work, or your business, or your relationship with people, or the companies you patronize, or the vendors that patronize your company, and begin to think about who is processing, who is the controller, who is the processor, and how all these terminologies interplay. So the controller is the person that determines the purpose and the means. I will use Adetumade and myself as an example. His company reached out to me and they said, oh, we should come and speak. And they said it is going to be physical or virtual. And they need my information. Now, they need my information for their own purposes, which they have decided for the purpose of training is their purpose. Now, the second thing is means. How will they process my data? First of all, they are processed it through emails. We've exchanged emails. If they are going to pay me, I would send them my account details. And they are collecting my account details for the purpose of payment. They are the ones also determining why they are collecting my data. They have decided to use Zoom. They are recording this Zoom without obtaining my consent. I won't sue them for that, but it's something I can sue them for. And they have also decided to store it. So I'm using all these examples for you to know that they are the ones calling all the shots with respect to processing of data. All of you here, they are doing video recording, they are taking photographs, they are the ones that will determine what they want to do with all those data they are collecting. They are the controllers. So controllers is from the word control. But sometimes you might not have control, but the law will still see you as a controller. Because of our time, I won't be, because this is not something we can finish in one day and there's still so much slides to cover. Data processor, those ones, you must understand they are engaged by contract. There has to be a contract. Contract, either oral or in writing, that mandates them to process data on behalf of the controller. The contract might be terms of use. In this context, Olumide and his company, Lawlexis, they are the controller. Zoom, they are using Zoom to process our data. Zoom is the processor. If they have another company with which they have been advertising this event or they have been registering us, that company will also be processor because that company is processing on their behalf. For you people that work in the company has recruitment agencies. The company has marketing agencies. The company has advertising agencies. Those agencies are your company's processor with respect to other people's data. But with respect to those companies' employees, those companies are controllers. I hope I'm not confusing you. Data subject. In all of this, everybody whose information is processed is a data subject. Everybody. So as we are in this place now, we are all Lawlexis data subjects. Then personal data breach. This one happens in different forms. And the one that almost everybody here is guilty of is bulk email. You want to send email to 20 people, you copy all of them. So I can see Olumide's email. Olumide can see somebody else's email. You can see, except we are in a company, except we are in the same group, except there is a reasonable understanding. Except there is a reasonable understanding that we are all supposed to share our data together. Then such is a data breach, and it is regular. Almost all organizations in Nigeria, you see the Nigerian Bar Association sending emails. You see so many other people's emails. You see the Nigerian courts. So data protection is, I know it's a marathon, it's a journey, but all of us, we need to get there. Nigerian courts, and this thing happened, I tell you. There's a senior advocate I've been wanting to see. I didn't want to go to his office. I didn't have his telephone number or something. I was just thinking in my head. Then maybe in the afternoon, then the court sent us hearing notice. Not hearing notice now, notice of adjournment of cases, the Court of Appeal. And for people who get mails from Court of Appeal, you will see emails of everybody, close to about 500 emails. That's a massive data breach. Massive. If he was in developed countries, damages. But everything comes to knowledge. Not until maybe 2 or 3 years ago, I did not know the essence of BCC in emails, blind copy. I used to have myself, why would they put blind copy there? Why are you going to be blind copy people? But now I get to understand. If you're sending bulk messages, blind copy everybody. Nobody is going to see anything rather than the email coming to you. I'll tell you one true life experience. A friend of mine working in a blue chip company, is a big boy there. Okay, sorry. He's a big boy in that company and he wanted to move. But he's their top guys, one of their top guys. He wanted to move. He went to another company in Nigeria to do interview. He had gotten to the final stage of the interview. But the final stage, they invited 3 people for the interview. But this guy didn't want to go for the interview because if you stepped into the place, they will see him. People will see him and they will wonder, this person wants to leave big company for, they might be wondering, what are you coming to do? Because they were rivals. So he didn't want anybody to see. So he had privacy concerns. He went for the interview. When he was getting back home, the company sent him a message. I also sent him an email. The HR, thank you very much so for coming for the final stage of the interview for the post of whatever. The management will take a decision and reach out to you. Lo and behold, they copied all the applicants. Other people that, somebody who went there quietly, and they copied everybody. So he saw other people who had seen that he went for interview. So if his company had got to know one way or the other, because those ones, that's what they do in corporate sector, I hear. Those ones could sabotage him in his current company. They could, it has happened to me. Somebody sent it to me before. Somebody screamed another person's email and sent it to me. These are privacy breaches and they are privacy invasions that we don't, naturally, we don't. So personal data breach happens a lot. It is not always where they hack. It is not unauthorized access, accidental access. You store very important files in a folder, then you misplace the folder. You store very important information in a flash drive. You store it on your system, and you give somebody to be watching Facebook on your system and everything. These are data breaches that we do not count, but they are so costly in other jurisdictions. A lady lost her bar license because she was going on the train. She forgot the folder on the train, a client's folder, and somebody else found it. They shut her out of the legal industry. But so these are regular things that happen, but we don't always pay attention to. Now, the principles. So for data protection, you must know these things. Principles and rights. They are very important because everything is woven around them. Now, the first one is the principle of lawfulness, fairness, and transparency. Lawfulness is lawfulness. You can't process data except there is a legal ground or a lawful ground. The law allows you to touch somebody's personal information. That is the only time you can touch it. There are exceptions to all these things. So the other one is fairness. And that speaks to the previous form I told you with respect to publicizing embarrassing facts. If you are processing somebody's data, you must respect the person as a human, understand the person has dignity. So if you are processing data of somebody who has low blood pressure or low sperm count, you understand that information, it's fact, but it has serious implication on the person. So you are processing it with all sense of carefulness, all sense of fairness. You're not just reckless about transmission of people's information and what have you. The other one is transparency, and that one is what most organizations fall short of. It means the public must know how you handle data. It means your privacy management, your privacy culture must be out there to the public. And how do you do that? Your privacy notices on your platforms, your digital platforms, or internally, privacy policies to your employees. The second one is data minimization. Now, under lawfulness, there are grounds. That one is also very important. The grounds of processing. So lawful grounds. Number one, you can process if you want to enter into a contract or for the performance of contract. If I'm having a contract with Law Lexis, they would need my name, my email address, my bank account, my qualification, so to speak, for them to be able to maybe agree to hire me or not to hire. So we would have to share. That is for the entry into contract. It is not just contract of employment, other contracts too. The second one is consent. That one is the most dangerous one. People think it is easy, but it is dangerous because consent can be given now and be withdrawn in a twinkling of an eye. So sometimes we advise clients to find other means. If they can't find, they cannot rely on consent. You give me consent to process your data, then I'm processing, maybe I'm using your picture. And a big example is the one, they use people's picture for an advert. maybe the person is working in the organization, then you leave. You have left the organization and you left in a very terrible distance. And you're telling them, I gave you consent when I was there 2 years ago. Now, I'm withholding my consent. Pull down. A client has done it before. They pull down the entire billboards, all the signages, because they have left. So that is why you wouldn't want to rely on consent. You would rather do contract. And the contract will clearly state all these things. Now, the other one is public interest. They can process in the event of public interest. That's what law enforcement agencies do. And in the event of life and death, that is vital interest. If somebody is about to die, somebody has an accident on the road, you won't be asking the person for consent before you reach out to the person's either laptop or telephone. You are invading the person's privacy. You are getting the person's data. But it is in the person's vital interest or a third party's vital interest. How the third party works is somebody has an accident, you reach out to the person's relative. The person might be quarreling with you. Where did you get my number? Why did you call me? The justification is that in the vital interest of this third party, that's why I've reached out to you. This third party has an accident. We need to save the person. You are the person's relative. You need to find the person and save the person. Legitimate interest. This is the most important one. It is the interest of the person. It is actually business interest. Interest of the business or of the corporation to process that data. But it has to be fair. So you see, sometimes organizations sending you marketing information. It is in their interest to send it. And they can always defend it. But legitimate interest also, it has qualifications. That is why in Europe, they have what they call legitimate interest assessment. Data minimization. I'll quickly move straight to this. Don't process data. Please just let me know in the chat box. Just always put it there when my time. At every milestone, put it there. So I think we are done with 1 hour now, is it? So that we can be able to maximize this. How many more minutes do we have, please? Just put it in the chat box.
Hey,
Olumide. Yes.
You have about an hour left.
Thank you. Thank you.
And that hour also for questions.
So I'll rush this. Thank you. So data minimization says only process the data you need. We were training some banks, and part of the question we asked them was, you guys ask, when I want to open an account, if anybody wants to open an account, you ask for somebody's mother's maiden name. What is your business with my mother's maiden name? I'm opening an account. Why do you ask? And they try to justify it. But the law is, don't collect more than you need, because more data, more trouble, more responsibility. Purpose limitation. Don't collect my data for business. Then you begin to send me love messages at night. Or you collect my data for a particular purpose, you begin to market something else to me. That's just what that means. That's purpose limitation. Limits the processing of data to the purpose of collection. Storage limitation. This one gives problem all over the world. Don't keep data for longer than it is necessary. The definition of longer than it is necessary is what even the world's most brilliant people are yet to answer. For every organization, it varies. For every company, it varies. But it's just that don't keep it forever. Because if you keep it forever, you have the responsibility forever. Somebody can come back in 20 years and 30 years and say, give me my data. It must be in your archives. Accuracy. For everybody who collects data, who processes data, you must ensure that the data is accurate and kept up to date. So you must update it. You must update people's data that you collect. I'll give you an example. A lady, it's a European case. I reported it in my case book. A lady went, I think a French lady went to Switzerland. Yes, she went to Switzerland. Kelili and Switzerland. She's French, but she went to Switzerland. And she wanted to hang out. She was at the side of the road. Maybe their own police too were doing stop and search, or they were carrying people. They arrested her maybe for loitering or for wandering or something. So they were searching her bag. After arresting her, they were going to detain her. Searching her bag, they found all sorts. They were trying to look for what her occupation was. So they found a card. In the card, she wrote, "This is a young lady looking for a man to hang out with." And with that inscription, they recorded prostitutes as her occupation. She went back. Then I think somebody told her that's the occupation they recorded for her, prostitute. Then she complained that that's not employment. Maybe she told them business or something. Then she went back to Switzerland. Maybe 2 years later, she found out that her data had not been updated or it had not been corrected. She sued them and she got damages under this principle. Then accountability, everybody who processes data must be accountable for its safety, must be accountable for its whereabouts. I can't give you my data and you say it is lost. If it is lost, that is a data breach, and it puts liability on the company or whoever collects. Integrity and confidentiality, this speaks to security and also confidentiality as we know it. Unauthorized access, don't give persons, don't just, it is not a data you can share with everybody in the world. Then security, you must have security measures to be sure that they are safe in your custody, and people don't just have indiscriminate access to it. Now, the rights. The very first one is the right to be informed, right to information. And that's why we talk about transparency, principle of transparency. This right interplays with the principle of transparency, that if you're transparent, then from your transparency, I should be able to get information on how you keep and process my data. Or if I reach out to you asking for certain information on my personal data, you must be able to give it to me. It also speaks to access. Sometimes you also want to have access to your data in somebody's custody. Maybe you don't even know the kind of data in the person's custody. You don't know how they got it. You don't know what they use, you can have access to it. That's the second right. The third one is erasure. Somebody has your data, you want it completely erased. You know how we used to say, delete my number. You know how we used to say, I don't want. So sometimes people send you unsolicited emails, or you have to reach out to them and say, you know what, please take off my emails. There was an organization in Dubai that I was part of. They were always doing meetings, and I got tired of their meetings. So I told them to stop sending. I specifically wrote them an email. Please take off my what's it called now? Take off my email from your database, and they did that. Data portability. If you have data with a certain organization, you can request that they transfer it to another organization, provided they have the means to do that. Rectification, yes. I have a personal experience in rectification and how it plays out. The reason why rectification is important, rectification and accuracy. Accuracy is a principle, rectification is a right. So for every principle, you have a right to activate that principle. Rectification, yes. So somebody says for the erasure unsubscribe does, sometimes it doesn't. Some websites that you have unsubscribed many times, they still send you. So yes, you might click the unsubscribe, but if it doesn't work, you have a right to actually demand rectification. I tell you why that thing is dangerous. If you don't rectify people's data, if you keep wrong data, it is dangerous. It's and how it impacts privacy. In 2013, I wanted to go to the UK. I applied. They denied my visa. They said I did not have money and I will run away. Okay, so I left it. And I said I wasn't going again. Then I had an invitation in 2017 to a conference. So I went. They gave me visa. But at the port of entry, they stopped me. They asked me to sit down somewhere. They gave me a detention form. Like they were detaining me and they would send me back to Nigeria. At that time, I was already, I don't know if I was crying or praying. Then after a while, they came back and said, okay, I was okay to go. So I entered. That was 2017. 2017, I went there twice. The second time again, they detained me. There's a way they would just ask you to sit down. Everybody passing by will be looking at you with one pity eye like that, like, oh, this one is going back home. And they will give you the detention form. They did that first time, second time, third time, fourth time. In fact, all the time I've been traveling to the UK, they've been doing that to me. I didn't know data protection all the while. I didn't know anything about it. So when I became aware of data protection 2020, when I traveled, they did that again. And I asked one of the immigration officers there, But what is the meaning of this? I've been coming here, I've never jumped the visa. And the guy told me that on my record, my detention, my denial of the first time is still on my record. And he told me in clear terms that forever, that is how they will be detaining me at the point of entry every time. So what did I do? When I got home, I sat down, I wrote them a strongly worded letter, and I cited provisions of the GDPR. That this is a violation of my privacy. If you even ask me to sit down, everybody passing will even see me. That this one has been detained. People who did not even know you traveled, they will meet you there. And because data protection implicates privacy, data protection is interwoven with privacy. I wrote them like that, and I told them, and I demanded that they should rectify that. How many years ago? Well, 9 years ago, 10 years ago, or much more than that. That denial is no longer relevant. So if it is no longer relevant, you can't still be keeping it. In fact, by their laws, all immigration records, they are kept for 5 years or so. After 5 years, they are no longer relevant. Sometimes they are deleted completely. So my record should be rectified, not to reflect. It should be rectified to reflect the current status, not the old status. They did it. Afterwards, I've been going in and out without any problem. So I just told you how rectification works and how it can affect somebody who has a criminal record. In your company or at the bank or wherever, you have the criminal record. The person eventually got acquitted, discharged and acquitted. No criminal record again. But you still have it in your record. That thing will continue to negatively impact that person because you'll be looking at him like a criminal. But by the law, or in the sight of the law, he's not a criminal. He should not even have that record anywhere again. So that's how it works. Then objection to further processing. Somebody might be processing your data, but you are not sure whether you want them to continue or you want to correct something or you want to erase something. You tell them to stop for a while before you make your decision. Then non-subjection to automated decision making. If computer is going to determine my fate, then you should let me know so that we can both analyze the logic behind that computer. It's just like VAR when people play football. You know how painful it is when you score and you jubilate. The fans have started rejoicing all over the place. We are celebrating, and they not call you back. VAR says no. Imagine that footballers are not aware that it is VAR. Do you know they can actually do it? They can do it. That they won't even be showing us the VAR. VAR will just be something. Even fans will not see the VAR. It will just be something. But that implicates privacy actually, because it controls a certain section of people's lives. So non-subjection. This is mostly common in banks when people apply for loans, and it's in foreign banks. If you apply for a loan in a foreign bank, there is an app that will evaluate what they call credit status. It is with your credit status that they will give you loan or they will not give you loan. So if the machine makes mistakes or we don't understand the logic or they did not even tell you, that it's the machine that is making mistakes, that's a violation of privacy actually. And the law says you should not be subjected except you are informed and the logic is explained. ATM, this is some of the things that ATM machine does. ATM, you go to ATM will say insufficient balance, or the ATM carry your card, or ATM. But Nigeria, we are not there yet because even ATM machines, they don't have privacy notice. And I've written something around that before. Okay, so somebody raised his hand. Okay, so.
Good afternoon. I don't know if you can hear me.
Good afternoon. Yeah, we can hear you.
All right, my name is Ayodele Samuel Adeputon. I must thank you for this data protection, I'll call it tutorial, because I'm learning new trend in this aspect. My question is, in the new PVC that was issued by the INEC, there are some of our details that they were there, like for example, I registered in 2011, and I just recently transferred from Ondo State to Abuja. But some of my detail, some of my old detail that was there has not been fully rectified. just say, for example, my occupation. By then, when I registered 2011, I was a student. Now I'm a lawyer. But up to now, nothing. I've collected a new one. It's still reflecting that I'm a student. So how do we rectify that? Thank you, sir.
Okay, thank you. So I'll finish this last slide. This last slide, and I think that's the last of my slides. Then we will now go into the questions and answers. This thing. So now remedies. The first one is the organization that breaches data can be fined by the regulators. In other parts of the world, they give people serious fines. Facebook, the kind of fines Facebook has been sanctioned. Google, even Amazon, even British Airways. Even Spotify. All these tech companies, there's no how you want to do tech. There's no how. Even you're not doing tech, even you as lawyers. I see lawyers now on WhatsApp chat room. People will just share precedents. And lawyers can ask for anything. A lawyer can say, send me a letter of everything. We ask for precedents. And you see, people will send precedents with people's names, people's addresses, people's occupation, everything. You will send it to a fellow lawyer. You say, because we are lawyers. Which lawyers? We don't understand confidentiality. It's a big one. And so I know it is difficult, but it takes conscious effort to begin to take this thing seriously. You can redact it. You can make XXX remove somebody's name. You can remove the person. You can remove personal information. And in fact, in the UK, in some places, if you send documents with personal information without redacting, they will not process it. They will either send it back to you or something. They will specifically tell you, we don't need personal information, because that thing has grown. My neighbors in the UK, they sued another neighbor of ours because the person was using doorbell camera. And they said the doorbell camera was overlooking their own premises. They sued and they got damages. There's a similar decision that you can even read online on that. Now, after fines, damages, people can get damages in court, even from the regulators too. You can be compensated for it. Then another thing is you can ask, okay, just delete my data. I don't want anything. Delete what you have in your custody. Then data breach is criminal. It's criminal. So the Cyber Crime Prevention and Prohibition Act makes certain provision that frowns against unauthorized access to computers or to some other thing. So if you access somebody's computer, there's no how you would access a used computer without accessing personal data. I think that's all from me for today. Thank you very much for listening. Now we can take the questions.
I'm not sure Olumide earned the applause, so please can we give it up for?
Thank you.
Okay. Guys online, you didn't clap for Olumide now. No, but there's the reaction. All right, I see hands online. What's the name? In a seat. Is that it? In a seat, yes. Vanessa. In a seat, Vanessa, Victor Okon. Please keep your questions short, because we want to take 3 of you, then we'll come back to the house. Please, and when you're asking questions to your camera, in a seat, Vanessa, who's the last one? Victor. Yeah. Please, when you're asking questions, turn on your cameras. We'll come back to those of us online. Is anybody afraid of traffic? No traffic. No, I've taken 3. I'll take all of them and leave you guys. All right. That's it. Unmute yourself, please.
Okay. Can you hear me?
Yes. Loud and clear.
Thank you very much for this opportunity, sir. I want to find out, is there any difference between a data protection agreement and a non-disclosure agreement?
Okay, so yeah, so I'll just be taking them one after the other. Let me quickly answer the man that asked about PVC. You know, PVC is a very sensitive thing. You ask them to go and rectify now, you will not collect it back, or they will tell you it is not coming on time. So maybe you wait after the election, then you can write them. I know they have procedures for correcting these things. Just approach them, and they should be able to rectify it for you. So I think that should not be a problem. Now, somebody also again asked whether if we are to be so much aware about data privacy on everything we do, we will not have a more restricted life. So privacy is a personal decision. You can afford to, I know people who keep nudes on their telephones. Yeah, it's their decision, it's bodily autonomy. You can do whatever you want with your life. You can decide to even waive your privacy. Me, with my wife, I have waived my privacy. You can check my phone. You can do everything, even if I do, as if I have a choice. But this is a personal decision. If you want to be so restricted with your life, or you want to keep it open, or you want other people to control, or you want to have a certain measure of control, it's a personal decision. Now, for the data protection contract and the non-disclosure is completely different. Non-disclosure so what I would say, because I wouldn't want to say data protection agreement, because what you will most likely have will be clauses that both parties would say respect the personal data that we share with you. Non-disclosure is when you're actually sharing secrets, maybe trade secrets, or you want to go into business and you say, okay, for this one, these ideas, don't disclose it. Well, personal data is, I mean, it has to do with almost every contract that you will have to draft, or you will have to come across, where people's personal data will be involved. Some of the things that will be in except you are not talking about data protection agreement. The data protection agreement will talk about the kind of data you want to share, the duration of sharing, who you are sharing with, who has access, how it is secured. Those are the standard clauses. Then, after sharing, how do you return it or destroy? There's a decision in the UK. It's in my casebook. A company wasn't doing well in sales. They engaged a marketing company to help them reach out to their customers and to get more customers. In fact, no, to help them reach out to their customers, to be advertising for them. So this company A gives the marketing company access to its customer database, gives it to them. Just go and be sending messages to them. After a while, they appraised their activities and they said, this marketing company has not been effective. You know what? We're not doing again. Give us our customers' database. The marketing company said the company A was owing them that until they pay before they would return. And in fact, they said their contract did not disclose that they were going to return it. The contract, unfortunately, was a verbal contract. The court said it in its decision that part of the things that parties must agree on is destruction or deletion or return of personal data at the end of it. The data protection agreement would also disclose liability. Who is responsible for what? It must disclose status. Who is the processor? Who is the controller? I mean, we are joint controllers. For example, if I'm going to jointly organize an event with Adetumade, we are both joint controllers. We can determine the extent to which we are going to have access to data. We can determine the access to which we are going to share data. We can determine who takes responsibility for what. So if somebody says this picture has been used in an unauthorized manner, I don't have access to the picture. You have been keeping the picture. Then you have to take responsibility for that. So non-disclosure is what we generally sign when we want to keep some secrets. Privacy is different from secrecy. Privacy is right to just be. That's what they call it in that 1890 article, right to be let, not left to, let alone. Just let me be. I don't want intrusion. I don't want anything. I'm not secret about it. That is why data protection is funny. Some things you share on social media, they still have privacy implications. You still have reasonable. That is why I used to say that thing jokingly. That when some people grow up and truly, they will sue their parents. The way parents put children on social media these days, do you remember the boy that was begging the mother, "Mommy, please don't do this"? We might find it funny. That boy, yeah, he was begging the mother, but the boy might grow up and become so embarrassed because his pictures will always be everywhere. The internet never forgets. Some people use his picture now for memes. That small boy that was playing pranks with the mother 2 years ago, 3 years ago, and everything. So that's the thing with privacy. It is not secrecy. Non-disclosure is secrecy. Don't disclose it. Privacy and data protection agreement is the use must be regulated. It must fall under the provisions of the law. And there must be several clauses. You can just Google the standard clauses in the data protection agreement. We don't call it data protection agreement. It is called data processing agreement, DPA. And you might not have a full agreement. For some cases, you might just have clauses. I hope that answers. The next person.
Yes, thank you. Vanessa, please turn on your camera, unmute yourself, and that. Yeah.
Okay. Hi, everyone. Good afternoon, Mr. Olumide.
Good afternoon.
My question is about certain rights that data subjects have, right? So the right to withdraw consent, right? After you withdraw consent, it's believed that your data is no longer being processed anymore. But because it's not being processed anymore, is that enough of a consolation if these people still have your data anyways? You won't know if they are still processing it. All you know is that you've told them not to, right? You've told them that you're not consenting to it anymore. If they do it, they're in breach. But how do you know that is actually happening? How do you know that is enough, saying that you don't consent anymore? Taking back your consent, how's that enough to prevent them from processing it anyways, moving forward? And second question was about restricting processing. So from what I understand, when you restrict processing, you can restrict it for certain uses. So if you don't want your data to be used for maybe marketing or something along those lines, right? So if you restrict processing for that purpose only, it's not a blanket. Do you have to list out exactly what you don't want them to use your data for anymore? And what if it's what if they use it for more than right? We assume that they tell us everything. We assume that they tell us all the reasons or ways that they use our data, they process it and stuff. But if you don't know everything, and then you restrict it to a certain extent, but there is more. Sorry.
Yes, it's long, but I think you already get your question. Thank you. Brilliant question, by the way. Thank you.
Thank you. So the thing is, I'm always very excited when we talk about this because, trust me, this is the future. It's a $1 billion industry outside Nigeria. So, and for young people, if you can really, really catch the bug now, my practice now, like say 80% of my practice now is data protection. Yeah, I still do other things, but I see it's a booming industry and something we really need to develop expertise on. And yes, that's why I started by saying I am not an expert. There's so many questions that even people processing cannot answer because some of these things are not realistic. Yes, Vanessa said something about consent. Yeah, so consent, you just say you withdraw your consent, but you don't know if they are still storing it because processing is also, storage is also part of processing. But I think the best way to know whether your consent has been given attention to is if they have been sending you messages and you say, you know what, stop sending the messages. If they stop, then, you should just be fine with that. There is nobody in this world that can know if somebody has deleted. How? If they show you their system, oh yeah, we have deleted. What if they keep it elsewhere? Even the regulators are not killing themselves on that. The only thing that would sell them out is when they use it again and they reach out to you, or there's a certain processing that comes to your knowledge. That's when you know. Then restriction, yes, you can clearly state that, you know what, don't send me marketing message. I have told my bank before, don't send me marketing messages. You can be sending me every other thing, but marketing, I don't want. Especially things that I'm not interested in. And now banks, they do a whole lot of businesses. So they're not only sending you about financial products, they're sending you about several other things. There's a bank that used to send me, they're having food fair. There's some that used to have wine carnival. And well, it's fine, but don't bother. So you can easily say, you know what, this is not why we are here. Then, okay, I think that pretty much answers the third one. I didn't get the third one. Was it 3 questions or 2? I only took down 2.
It was 2. You can't
Thank you. Thank you, Vanessa.
All right. Victor, finally, from our online guest, Victor. I'm sure I got the name right. Sorry, for everybody online, sorry. There are people here. I know that right now you feel like we own the speaker. Please, let us to enjoy. Please. Thank you. All right. Was it Victor? It was Victor now.
Yeah.
Okay, there's no Victor. Let me see the screen again.
So we have Jamila, we have Pearl, we have Samuel, we have Miriam.
Miriam. Miriam,
Good evening, sir.
You've asked the question before.
Good evening, sir. Thank you. I have not.
No, she did not. She did not.
Okay.
My question is, as a data compliance officer in a tech company, what areas of data are we supposed to focus on to make sure that the tech companies don't breach? What areas of tech? If you're advising as a data compliance officer in a tech company, advising a tech company on data compliance, what areas of law should we focus on in advising them?
This sounds like advisory, but I'll send you my bill through Adedumade. This is like some consult. But number one, it depends on because tech, we can always generalize tech. So what do you focus on? Is it health tech? Is it ad tech? Is it
Rideshare tech? Rideshare tech.
Right. So first of all, you want to look at your platforms, all your platforms, the external platforms, the internal platforms. How transparent are they with respect to the privacy notice? That is the first thing. When we started the advocacy around NDPR, that's the first crusade we did. We started suing banks and suing everybody on privacy notice, because let's even start from there. That is what tells us you have a privacy culture. Let's see. And we saw a whole lot of funny privacy notices. And we said, you know what? This is just like you fulfilling all righteousness. This cannot protect the consumers. This cannot protect privacy of anybody using your services. So you want to start from there. And then you also want to generate your policies. You need to have so many privacy documents. And these things are online. All these things, I also get them online. They are all online. The regular privacy documents you should have. And the first one I will advise you is what we call data inventory. That's the first part of call. Anybody who understands data will start from there. Some people call it ROPA, record of processing activities. That is where you should start from. It's like the Bible of privacy documents. It tells you the department that collects. It tells you what they collect, not documents. Some people are always looking at, we collect this document. No. In the document, what are the information in the document? Some companies, I wanted to get a job from a company. They wanted to give us consultancy for them on privacy and data protection. And lo and behold, they said we should send them our statement of account for 6 months. So what's happened? But because we wanted the brief, we sent it to them. But when we entered, we changed it. We changed it for them. You can't be asking people for 6 months. What's the justification? You want to know how rich we are? Or you want to know who we have been transacting with? Or what exactly do you want to know? If you ask us to send you our account balance for you to know our turnover, it is different. But you're telling us to send you a 6 months. So all the money we send to our mothers, our fathers, everybody, no. So that's a lot of invasion. So I would ask you to start from there. But you can't be a compliance officer without focusing also on personal data. So your attention should be on personal data. Because some people will say, some tech companies will say, hey, we don't process data. But if you develop products that process data, then you are a processor. And one way or the other, you might become a joint controller. If you have the slightest of access, you will either become an independent controller or so you have responsibility. So you want to start all your privacy culture from, first of all, developing privacy documents. It is from there that somebody will say, okay, even if you don't use it, you know how we gather documents and we don't even know how to use. You start from there. Then from there, you can now start training yourself and your colleagues on how to work those documents. That will be all for the money you are going to pay.
Thank you very much, sir.
Okay, we come in-house, we come real time, we come in class. First, please direct. No, by the way, we can't sleep here. Sorry, sir. Olumide. Many of your questions are answered in your books, right? Great.
Definitely.
So,
help my ministry.
Thank you. So we are going to take, like we did online, we're going to take only 3 questions.
At least if we have about 80 people online, I don't know how many people offline. If all of you buy, I will buy land in Banana Island.
We're going to take only 3 questions. I saw his hand. I saw a hand. Anybody on that side? So you have to be privacy compliant. Okay, let's go.
Okay, thank you. Good afternoon. My name is Gisun, Interprime Law Practice. When you want to buy land in Banana, I sell, so we could talk on that. Okay, so yeah, I have a client that has one of his contacts was harassed by these loan sharks. His contact was harassed by a loan shark. She had borrowed some money from the loan shark, and he has nothing to do with the transaction, of course, but he received a message on WhatsApp, actually multiple messages on WhatsApp, telling him that, his daughter, or whatever term they decided to link them with, had stolen money and was on the run. You know how they talk and all those kind of stuff. And they were harassing him that he should pay the money on her behalf. So he approached us and he was like, no, I feel attacked. My data, my privacy is being breached. My privacy is being breached, and I want to do something about this. So now there are 2 sides to this question. The first side is for this person, he's not the person who is being defamed. His information is not being spread out and, all sorts of false things being said about him, but he feels assaulted by the people telling him to pay, and why do they have his contact and all that kind of stuff. Then the second part of it is that the girl in question, she signed up with only one loan shark, but now she has received messages from so many different loan sharks telling her to pay what she owes them, and she has never heard about them before, meaning that the first loan shark leaked her data. And so the question is, on both sides of this scenario, that was it. On both sides of this case, what can be done? That is the question.
Pay Olumide.
Thank you. So we don't waste time. Of course, both of them can file suit. I see a lot of no we don't get to file. It's just all of them. Both of them have claims on privacy violations, even data protection violations. Yes. Even if she consented to sharing her data with whoever, that's not proportionate. So, there are exceptions to, they might say she gave consent for you to go and malign her or what. Nobody would give that kind of rubbish consent. How much are they even giving people? But it's just unfortunate that we are not suing. We are not. I've not heard about any judgment against any of the loan sharks. And there's hardly any family in Nigeria who has not received it. Anyway, I've taken one of them to court. Maybe before the end of the year, we'll get judgment or something. But we need to do more of that. That's just it. Thank you.
All right, straight to the point, please.
Thank you. My name is Ifoma again. So you already stated that the NDPR is grossly inadequate, which I agree. And so now I could see that some of the things, majority of what you've mentioned in your slides are from the GDPR. And the GDPR does not only apply to countries in the EU, it applies to other countries out of the EU that have components of whatever of that company in the EU. So using Nigeria as an example now, we are supposed to use the NDPR, being a country domiciled in Nigeria, but where the NDPR is not adequate and we have to use the GDPR, are we going to use it in court, or how is that supposed to work? And now we are supposed to submit a data audit. NDPR have said we have to do an audit, but the laws is not even adequate for the audits that they're asking us to do. So how do we go about it?
Thank you, Informa. So very quickly, straight to the point. When I said you should be careful of the NDPR also has an implementation framework that helps you to understand the NDPR or helps you to enforce it. You can also Google it. It's online. Implementation Framework 2020. Now, a funny clause in that framework, I also wrote an article against the framework because the framework is also has its own shortcomings. But a funny provision in the framework says where the NDPR or the framework are inadequate or is inadequate, you can rely on GDPR. So, which is funny, how we would enforce GDPR in Nigerian courts. It would be very funny. I would argue, I wouldn't make that kind of argument, but maybe not necessarily rely on sections of the GDPR, maybe rely on provision, maybe rely on guidance that you can get from the GDPR. So that is what the NDPR says. The lacuna or the shortcomings, you look forward to the GDPR and everybody. But in terms of enforcement in Nigeria, I'm not sure I even want to advocate that yet. If we are talking about laws in the UK, yes, but not a regulation that is not known to Nigerian law, so to speak. That can be referenced to it, but not enforcing it.
All right. Sorry.
Good afternoon, sir. Thank you so much for a very insightful and interesting session thus far. My name is Tony Asada. My question is, my first question is more like, I think when you were defining the terminologies, I think you skipped the one about anonymization and pseudonymization. Maybe I missed it, but I think I asked people around me and they don't have definition. Then my second question is about, I want you to comment on it, some trends online where you're trying to subscribe from like an email marketing or listing, and it's as if they are doing it on purpose, because when you click on unsubscribe, they redirect you to another page instead. Or sometimes even these issues with cookies, accepting or not accepting, some will put columns where there's no option for you to not even accept. So that's my question. So what's your comments on this? What do you think can be done, or can nothing be done? Thank you.
Thank you. Okay, so anonymization and pseudonymization, they are security techniques. So we talk about the last principle. I'm sorry I skipped it. The last principle is about integrity and confidentiality, talking about, and I spoke about securing from unauthorized access or unauthorized disclosure. So in some organizations, in fact, I have a case in court for that. In some organizations, I will speak about the case shortly. In some organizations, because of the sensitivity of the data, everybody does not have access to certain data. So if you see something online or you see something in their computer networks, it will just be the codes. For example, some HR use codes to represent files. So if a non-HR member see the files, they won't know who owns what file. So that is pseudonymization. Pseudonymization is the use of codes to represent personal data. But the difference between anonymization and pseudonymization is that pseudonymization, you use codes, you use symbols, but you can still you can identify them. You can identify. Who is that one wearing top? Maybe you have to mute someone online. I hope she knows. Adedumade, you might want to mute everybody online so that we don't go and invade somebody's privacy. Right? Now, and that's pseudonymization. That is using codes, but those
said, sorry.
Okay.
Olumide,
so
you can
you hear me now?
Yes.
Can you hear me now?
Yes.
So the pseudonymization is the use of codes, but they can still be identified if you use additional information. If you use codes, maybe you have where you store the original files, you can get them. But anonymization is you turn personal data to certain extent that you can never identify them again. Maybe somebody's file, somebody went to Unilag, somebody gives you a certificate. The person went to Unilag, the person's name is there, you leave Unilag there, but you remove the person's name completely, you remove the person's matric number completely, you remove the person's year of graduation year, you remove it such that that certificate is useless. Nobody, even Unilag, cannot identify that certificate because you have removed the very important and identifiable information there. That is anonymization. That is how to anonymize personal information. So they are security techniques. And for anonymization, they use it. What is just left in anonymized data is to be used for statistics. For example, you want to count the number of employees that have worked in a bank or that have gone to a school. You don't need their name. Maybe all you just need is their serial number might identify them. Maybe you just get a list and just put the state of origin, the state they came from, your state, Lagos State, and you just put it there. So the states represent each student, and you know the number of students. So that's anonymization and pseudonymization. Then the other question is the unsubscribe. That is what I said about companies not being very compliant. It is deliberate. It is a marketing strategy. It's a marketing strategy. Once you fall like this, sometimes to get out of it. But in Europe and other parts of the world, they used to find those companies. I know a company that has been fined, big fine for cookies that don't allow you to opt out. I know companies that have been fined for not giving options. Even in Germany, a law firm was fined big time for the privacy policy not being explicit enough. So these are things that happen in real life. Yeah.
All right. Olumide deserves a round of applause again.
Thank you very much.
I'll tell you, 1, the slides were given. 2 is, at least Olumide, we can share your email address with everybody now. You have even shared it. You have shared it.
I've shared it.
That's you see, you have his email address. He has breached his own privacy. Then, of course, we have his books, and then we're running really out of time because you don't want a funny situation where if we stay, this NEPA will just take light, and then they will say NEPA is taking light and it's past work hour. I'm not even lying. I went to the toilet. I wanted to take tissue, and there was no tissue. And I said, dude, please, can I get tissue? He said that it's past work hour. And because it's past work hour, if he goes to ask for tissue, they will think he's taking it away, and so they won't give him. So please, have I convinced you enough that your questions are important, but you can ask in other channels? Thank you very much. And on that note, please, we are going to clap one more time for Olumide.
Thank you. Thank you very much for the invitation.
And then we'll clap for Adedumade, the convener, as he comes to round up now. Thank you.
Well, I've seen so many comments online already. Everybody loved Olumide's session. And funny enough, he was the only one today that has been virtual. And it's just wonderful to find out that everybody enjoyed it. Please, a round of applause for him again. Thank you so very much. We appreciate you, bro, and we hope to see you again on another one of our online or in-person sessions. Thank you so much. To the people online, thank you for joining us today as well. And the people here in the classroom, thank you so much for joining us. We're winding down for today. Tomorrow, we have another exciting day. Our modules for tomorrow include blockchain technology, startup compliance, and intellectual property as well. And I promise you tomorrow is also going to be as engaging as today. But I have one question. So tomorrow is Friday, right? Does anybody want to do TGIF? So we can have a small networking event after tomorrow's session in the evening, just for about an hour, just have a few cocktails and just hang out, get to know each other, so we don't just run off. But why I'm asking is so that we know if we should do it. Not that we do it now, people will now run out the door and it will go to waste. So if you want to hang out cocktails tomorrow, say hi. If you don't want, say nay. The eyes have it. Thank you so much. So we'll get to
Zoom
hang out
people, drop your
tomorrow
hands. You
evening.
cannot eye here, Joe.
All right, guys. If you're online, thank you so much. Join us tomorrow at 9 a.m. as well. Enjoy your evening.
All right.